Namaste. Welcome, friends, to the 37th session of She and Rights. The theme for today's session is Protecting Maputo Protocol is critical to resist anti-rights pushbacks and advance gender equality and right to health. As you might be knowing, She and Rights is dedicated to helping advance gender equality and human right to health, both of which are inseparable fundamental human rights. She and Rights is together hosted by Global Center for Health Diplomacy and Inclusion, or SEHDI, and CNS, with partners including International Planned Parenthood Federation, or IPPF, Asian Pacific Resource and Research Center for Women, ARROW, and Asia Pacific Media Alliance for Health, Gender and Development Justice, or APCAT Media. A few quick housekeeping announcements. Participants can please type in their questions and comments in the chat box even as the speakers present. Please also mention the name of your organization if possible. We will take up as many relevant questions as time permits after all the speakers have presented. Also, please keep yourself muted as the speakers present. Those who want to read subtitles or captions, in a language other than English, then please click the YouTube link which is given in the chat box. Then go to the settings, click on subtitles or closed captions, click on auto translate and select your language. Friends, we are also excited to announce the next 4th edition of She and Rights Awards 2026-2027. All journalists and other media actors in African and Asia Pacific regions are most welcome to apply if they are reporting on issues raised by She and Rights sessions held during May 2026 and December 2026. The award ceremony would be held around the 40th General Assembly of the African Union in February 2027. There are 3 award categories: the African Regional category, the Asia Pacific Regional category, and a special category for media reports for countering the onslaught of anti-rights and anti-gender pushbacks, such as the draft charter. The link to apply for the awards is in your chat box. Today's session is focused on the regressive draft African Charter on Family, Sovereignty and Values, which threatens to undermine progress made on gender equality and right to health in the African continent. This draft charter is yet another attack on sexual and reproductive health, rights and justice, as well as bodily autonomy and human rights. It urges African governments to withdraw from progressive and rights and evidence-based agreements, including the historical and legally binding Maputo Protocol of 2003, which has been playing a defining role in promoting gender equality and protecting reproductive and health rights of women and girls in Africa. Amid growing global anti-rights and anti-gender backlash, this draft charter is an additional assault that attempts to backslide the progress made on gender equality and right to health, both of which are indivisible fundamental human rights. Let us begin today's She and Rights session with a message from Dr. Tialeng Mofokeng, United Nations Special Rapporteur on the Right to Health.
Greetings, everyone. Thank you to the Global Center for Health Diplomacy and Inclusion, SEHDI, CNS, and partners for organizing this important She and Rights session today. Only 54 months are left to deliver on the promise of gender equality, the SDG 5, and health and well-being, which is SDG 3, by 2030. But the sense of urgency and purpose is missing if we recognize that the world is not on track to deliver on either of these goals Instead of going forward, in many instances, we are spilling backwards. Gender equality and human rights to health are fundamental human rights, and both are indivisible or inseparable. But despite this, anti-rights and anti-gender pushbacks have been growing, stalling, and at times trying to reverse whatever progress has been made on gender and health rights, especially for girls and women and gender diverse communities. The regressive draft African Charter on Family Sovereignty and Values is yet another assault on sexual and reproductive health rights and justice, as well as bodily autonomy and human rights in general. More importantly, this draft charter urges African governments to withdraw from progressive and rights and evidence-based agreements, including the historic and legally binding Maputo Protocol of 2003, which has been playing a defining role in promoting gender equality as well as protecting reproductive and health rights of women and girls in Africa. Among growing global anti-rights and anti-gender pushbacks, this draft charter is an additional attack which is attempting to backslide progress made on gender equality and human rights to health. This draft charter is the first African continent-wide patriarchal push to dislodge human rights and replace rights with so-called moralistic viewpoints. We cannot undo progress made by years of dedication and decades of struggle, which have resulted in strong and legally binding commitments, such as those enshrined in Maputo Protocol. Governments need to disengage with this draft charter and instead honor and deliver on the promises they have made on gender equality and human rights to health, where no one is left behind. And these are international human rights laws which are binding and have human rights obligations on states. This draft charter wrongly claimed that sexual and reproductive health, rights, and justice are so existential threat to African communities and families. The reality is totally the opposite. It is patriarchy and anti-rights and anti-gender pushbacks that are threatening to become an existential threat to African families. Not autonomy, not respect, not dignity, not equity. And globally as well, if we see with rights and justice for our rights, women and people in all diversities, we will see this pushback. Whether it is comprehensive sexuality education or the right to safe abortion, these are hard-fought gains, despite and in spite of anti-rights pushbacks. We cannot let these gains on gender equality and the right to health wither away. Governments must disengage and reject such a regressive attempt. This draft charter is trying to prioritize so-called family over individual rights, which risk legitimizing subordination of girls, women, and gender diverse people. Such a regressive attempt will also wrongfully firewall families from accountability in situations such as violence, coercion, or discrimination, making it impossible for vulnerable girls, women, and gender diverse people to seek justice where needed. It also wrongfully defines what a family is. I would like to close with the remark that gender justice and human rights to health are not negotiables. Rather, these are essential bedrock for human development, for sustainable peace and security. I thank you.
Thank you, Dr. Tialang. Thank you for your very powerful message. I now invite our keynote speaker, Sibongile Dashe, Executive Director, Initiative for Strategic Litigation in Africa, or ISLA as it is called. Sibongile's work is driven by developing jurisprudence in gender and sexuality before the African human rights system. The link to ISLA report, which has done an in-depth analysis of this regressive and problematic draft charter, is in the chat box. Please save it and read it later. Now let us listen to Sibongile. Welcome, Sibongile.
Hi, good afternoon, everyone, and thank you for having me here. Shobha, can you please confirm how much time I have?
Oh, you can take as much time, Subongle. You can take 15 minutes if you want to or
Okay,
more. Yes,
fantastic,
please.
fantastic.
Please.
Okay, good.
Yes.
So, I come from an organization that is known as this Initiative for Strategic Litigation in Africa, ISLA. And today I want to talk to you about this draft charter that Dr. Tlaleng has just mentioned. It is important to know from the very onset that this charter has been developed over a period of time through these things called the Interparliamentary Conferences on Family Values. What I'm going to do with our time is to really take us through the legal architecture of this draft charter, our key findings from the article by article analysis that we have. And if we have time, we can look at the areas of divergence from African and international human rights standards and the implications for state obligations and treaty commitments. And finally, looking at the risk that are posed to the African human rights system. This draft charter frames itself as a response to foreign ideologies. And this is attractive to many people who are still battling the long-term effects of colonialism. It also frames itself as a defense of African culture and sovereignty. It also says it's a protection mechanism for the African family. So it claims to protect family systems, religious and cultural values, national sovereignty, and educational and health systems. And these are things that are important to many people across the world. So what I'm going to try and do is to examine what each provision seeks to do, where it fails, distorts, or omits, or regresses. The central findings that we have, that's the basis of this analysis, is that this draft charter is not merely conservative, but it constitutes a restructuring of rights through legal distortion. The rights language is retained in form, but the rights protection is weakened in substance. Sovereignty is used to resist accountability, and family protection is used to justify exclusion. Culture is invoked to limit equality protections, and human rights is reframed as a foreign ideology. And the result of this is that there is a shift from rights-based governance to values-based regulation. So Article 1 of this draft charter seeks to control the entire interpretative framework of the draft charter by fixing authoritative meanings for key legal, political, social, and moral concepts such as family, sovereignty, culture, sexuality, gender, SRHR, Ubuntu, and neocolonialism. The central legal concern with this article is that it fundamentally departs from accepted treaty drafting practice by using definitional clauses not to clarify legal meaning, but to advance ideological positions and delegitimize existing human rights standards. And this is obviously inconsistent with Article 31 and 32 of the Vienna Convention on the Law of Treaties, where Article 1 systematically reverses this kind of approach. Family in the draft charter is defined as primarily marriage between a man and woman. And get me right, I'm not defining a marriage, I am defining what family is. So family is defined through the lens of a marriage. It also includes biologically adopted children with secondary recognition of extended kinship structures. This directly conflicts with established international and regional human rights jurisprudence. The practical implication is profound because family recognition determines access to inheritance, housing, custody, migration status, social protection, and legal recognition before the state. There's also something called the family-centered approach. And this draft charter frames the family as a primary unit for policy design, governance, and service delivery. It prioritizes family welfare, family cohesion, and family authority above individual consideration. This becomes especially dangerous where families themselves are sites of violence, coercion, discrimination, or unequal power relations. The Charter provides no safeguards, ensuring that prioritizing family cohesion cannot override women's rights, children's rights, bodily autonomy, or protection from abuse becomes the thing that's important to us. There's also a definition of something called the family impact lens. This introduces a family impact lens requiring laws and policies to be evaluated according to their impact on family stability, family cohesion, and family values. The problem is not simply conceptual ambiguity. The deeper concern is that this lens becomes a mechanism for filtering all rights claims through a predetermined ideological standard centered on cultural conformity, parental authority, and prescribed moral values. The Charter does not require this lens to operate consistently with equality, non-discrimination, women's rights, children's rights, or proportionality. It's structurally incompatible with the African human rights system because it allows collective moral claims to displace individual rights protection. It also defines gender ideology. It frames gender identity, gender equality, and LGBTQ protections as ideological, harmful, externally imposed, and incompatible with African values. We do know that international and African human rights law do not treat gender as an ideological construct imposed externally upon states. Rather, gender analysis exists as a legal framework for understanding how social structures produce inequality and discrimination. And that is why we are proud of the Maputo Protocol. We own it as an African instrument. This document tells us that these are all foreign imposed ideas. The draft charter reverses the established jurisprudence by reframing equality protections as ideological threats. It also defines sovereignty. The draft charter expands sovereignty to justify extensive state control over morality, health, education, sexuality, and family life. We know that under international law, sovereignty is not absolute. African states have exercised sovereignty precisely by choosing to ratify the African Charter, the Maputo Protocol, CEDAW, CRC, and other instruments. It also defines Ubuntu. The draft charter invokes Ubuntu as a communitarian African ethic, grounded in collective moral authority and family-centered governance. Ubuntu has historically been interpreted within African jurisprudence as a philosophy supporting dignity, solidarity, care, equality, and shared humanity. The South African Constitutional Court in the State versus Makwanyane case invoked Ubuntu as consistent with the respect for the inherent dignity of persons. So instead of using Ubuntu to deepen dignity protections, the Charter instrumentalizes Ubuntu to justify subordinating individual autonomy to collective moral authority. This is only in Article 1 of this, which deals with the definitions. So quickly running through the purposes and objectives. Article 2 frames the draft charter as a comprehensive restructuring of African legal, social, political, educational, and governance systems organized around a singular conception of family, sovereignty, religious values, and cultural morality. The provision positions the protection of the heterosexual family model, the defense of African sovereignty, and resistance to external influence as matters of national survival, political security, and continental integrity. It further seeks to authorize African states to review, reverse, reinterpret, or reject laws, treaties, and policies considered inconsistent with the draft charter's moral and ideological objectives. It also frames protection of the family as essential to national stability, social order, sovereignty, and regional security. It treats threats to the prescribed family model as threats to African governance, continental sovereignty, and political order. There are principles under Article 3 of this charter. It invokes concepts that are familiar to all of us within the African human rights systems. It speaks to equality of men and women before the law, non-discrimination, impartiality, fairness, and due process. But it does not merely affirm equality and non-discrimination. It requires that all charter obligations be interpreted and implemented through what the draft charter calls a family impact lens. The equality guarantees are narrowly framed and selectively constructed. The omission is not legally neutral. Article 3 refers to equality of men and women before the law, but it does so only in formal sense. It does not recognize substantive equality or the structural inequalities that women and girls experience in practice. There are commitments to preserve and protect the African family under Article 4, and this provision requires states to systematically review existing laws and policies through this family impact lens, withdraw from or nullify instruments considered inconsistent with the Charter's values, reinterpret binding obligations where withdrawal is not impossible, entrench a heteronormative definition of marriage, restrict sexual and reproductive health and rights, elevate parental authority over children's autonomy, and promote a state-endorsed moral model of sexuality and family formations. In effect, Article 4 functions as an enforcement mechanism designed to institutionalize this draft charter's ideological premises within the domestic and regional legal system. Article 5 deals with commitments to preserve and protect religious and cultural value. It speaks about protecting African cultural heritage, promoting indigenous languages, preserving traditional knowledge systems, recognizing indigenous communities, and affirming religious and cultural identity. But this article does not merely encourage cultural education or recognition of heritage. It mandates the enshrinement, inculcation, and institutional protection of a prescribed set of values across education systems, public policy, judicial interpretation, budgeting, language policy, and state governance structures. In effect, culture becomes not simply a social reality to be respected, but a state-directed normative framework through which law itself must be interpreted and enforced. Article 6 deals with commitments to protect children and strengthen the national education system. It goes much further than educational reform. It departs from this framework by redefining education primarily as an instrument for preserving a prescribed moral order, defending sovereignty, and protecting state-defined cultural values. It explicitly seeks to eliminate comprehensive sexuality education and replace it with abstinence-focused ideologies, and to apply a family impact lens across educational content and policy. Article 7, these are commitments to protect national health systems. It does not stop at health sovereignty or institutional strengthening. Instead, it reframes health governance itself as a mechanism of moral regulation, ideological resistance, and state control over bodily autonomy. It rejects SRHR frameworks and explicitly denies the existence of international obligations relating to abortion rights, which is what the Maputo Protocol contributed to the development of international law. It also transforms health from a universal human rights obligation into a sovereignty-driven and morality-based regulatory framework. There are also commitments to protect food and natural resources. The article speaks about food sovereignty, control over natural resources, agricultural independence, environmental protection, indigenous knowledge systems, and resistance to exploitative global economic structures. It calls for strengthening of intra-African trade, promoting local production and value addition, protecting African land and resources from external domination, and reducing dependency on foreign corporations and external markets. This sounds like something that we can believe in. But the problem is African Article 8 reframes food systems and natural resources less as sites of human rights protection and more as strategic instruments of sovereignty and political control. While the draft charter identifies legitimate concerns regarding global inequality and resource exploitation, it responds to those concerns through an excessively state-centric sovereignty model that risks weakening rights protections, limiting participation, undermining accountability, and subordinating food, environmental, and land. I think I'm coming to the end of my 15 minutes. I'm skipping what they talk about national economic development, but I hope you do understand of human rights norms. It's there. But the scariest thing is what is found under Article 11, which is a committee. So this thing establishes a new AU African Union body called the Committee on Family Sovereignty and Values, mandated to protect this draft charter. This committee risks functioning less as an independent expert, restrictive interpretations of family, gender, sexuality, and cultural identity. It provides no meaningful safeguards regarding independence, accountability, pluralism, or consistency with binding African human rights laws. And it is designed to function in ways which are similar to the African Commission on Human and People's Rights. So thank you very much. I'm going to stop here, and if there are questions,
Thank you very much, sister, for setting the stage and sharing a deep analysis of this regressive draft charter. And it's really very frightening and scary to see that such things are in the offing. Our next speaker is my friend Lethogolo Mogoren, South African legal practitioner practicing as an advocate and also a member of the Johannesburg Society of Advocates. They has been on Shian rights panels before. Welcome, Lethogolo.
Hello, everyone. I just want to make sure, are you able to hear me?
Yes, very clearly.
All right. Thank you, Shivnam. It's always a pleasure to come and speak. And thank you to all your partners for this convening. I want to begin by locating us in time and place. We meet 2 days after 16 June. In South Africa, 16 June is Youth Day. It marks the 1976 Soweto uprising when the apartheid state turned its guns on children who dared to assert their right to dignity, to education, and self-determination. Many of those children were girls. Their bodies were sites of state violence because they refused to accept that an unjust authority could dictate the terms of their lives. 50 years later, new authorities wearing new masks are attempting to do the same thing, to dictate to African women and girls what they must do with their bodies, whom they must love, how they must constitute their families, and what they may know about their own health. And just as those children in 1976 resisted, we must resist now. I stand here as a legal practitioner, an advocate of the High Court of South Africa, and an in-house counsel at the Center for Applied Legal Studies at the University of the Witwatersrand. I work on right litigation. I work on gender-based violent cases. I've made submissions to various organizations on the rights of queer people, on legal identification, on hate speech, and a number of other things. I say this not to list the credentials, but to locate my intervention. I speak as someone who has seen up close what happens when legal instruments are weaponized against the vulnerable, and what happens when progressive instruments are dismantled or allowed to atrophy. The threat we face. Let us be precise about what we are confronting. The draft charter on family sovereignty and values is a product of 4 interparliamentary conferences. The first in Entebbe, Uganda in March 2023, the second in Entebbe in 2024, the third in Entebbe in May 2025, hosted by the State House and the Parliament of Uganda, with direct participation of President Museveni and the First Lady, and the fourth in Accra, Ghana, from the 3rd to the 5th of June 2026, just 13 days ago. These conferences are organized by the Interparliamentary Network on African Sovereignty and Values and are supported, funded, ideologically, and shaped by international conservative organization, chief among them Family Watch International, a US-based entity headquartered in Arizona, which the Southern Poverty Law Center has documented as an anti-LGBTI organization that has spent decades challenging resources into Africa to change laws and shift policies. Its president, Sharon Shalter, has personally met with President Museveni and the First Lady, Janet Museveni. She has addressed these conferences. She has trained high-ranking African parliamentarians and UN ambassadors to oppose comprehensive sexual education and LGBTIQ+ rights. This is not speculation. This has been documented. At the Accra conference, 20 African nations endorsed a communique advancing this charter towards adoption by the African Union. Let me repeat that number. 20 nations. Ghana, the host, passed its own extreme anti-LGBTI bill on the 29th of May 2026, just days before hosting this conference. This momentum is real. The threat is not hypothetical. As Sibongile has wonderfully said, the initiative ISLA, through its Countering Anti-Rights Actor program, has developed the rigorous legal analysis of the draft chapter. It's called the Legal Analysis of the Draft Chapter on Family Sovereignty and Values 2026. Let me summarize its core findings, because it's essential that we name what this document actually does and not what it claims to do. First, as Sibongile has mentioned, the draft charter calls on African governments to withdraw from progressive, rights-based and evidence-based international and regional agreements. This includes the Maputo Protocol. It means asking states to withdraw from a legally binding instrument that has been ratified by 46 of the 55 African Union member states. 46. This is not a marginal document. This is a continental consensus on women's rights, and the draft charter would have African governments repudiate it. Second, the draft charter defines gender as limited to male and female, erasing the existence of intersex and gender diverse persons. It defines family exclusive, as Sibongile has mentioned, through heterosexual marriage and biological parenthood, excluding same-sex families, single-parent families, and chosen families from any legal recognition or protection. Third, the chapter rejects comprehensive sexual education, the very education that evidence has shown leads to a better sexual and reproductive health outcomes, lower rates of HIV transmission, lower rates of unintended pregnancies, and lower rates of gender-based violence. It replaces evidence with ideology. It replaces public health with moralism. Fourth, the draft chapter invokes sovereignty as a basis for non-compliance with international human rights obligation. This is a perversion of the concept of sovereignty. Sovereignty was never intended to mean that a sovereign right of a state to oppress its own people. The African Charter on Human and People's Rights, adopted in 1981 in Banjul, recognized this. The Maputo Protocol, adopted in 2003, deepened it. Sovereignty and human rights are not intention. They are both expression of the dignity of a people. Fifth, and this is what ISLA has warned us about, the draft charter uses rights language to strip rights. It speaks of protecting the family while removing protections from families that do not conform to its narrow definition. It speaks of African values while promoting values that were designed in Arizona and incubated in Washington, DC. It is a charter in sheep's clothing. I want to pause here and speak not only as a lawyer, but as someone who lives this. I am a gender diverse person. I do not say this as a footnote. I say it because the analysis that follows is not academic for me. It is personal. I know what it means to remove institutions that were not built for my existence. I know what it means to look at a legal instrument and see, encoded in its definitions, a decision that I do not belong. When I tell you that the draft charter does to gender diverse people, I am not speaking from a distance. I'm speaking from the inside. And what it does is not an inconvenience. It is erasure, legal, political, and in the most dangerous sense, physical. In the world of this charter, we do not exist. The charter defines gender as limited to male and female. It describes transgender identity as a gender ideology, a phrase borrowed wholesale from the American evangelistical playbook. And it deploys here, as it has an African term, and a phrase borrowed wholesale from the American evangelistical playbook and deployed here in the charter as if it was an African term of art. It makes no provision for intersex persons. It makes no recognition of gender diverse families, gender diverse parents, or gender diverse children. In the world the charter wishes to construct, these people do not exist. I do not exist. And when the law says you do not exist, the consequences are not abstract. Issa's analysis is precise on this point. The charter promotes a family-centered and sovereign-driven model that excludes protection related to gender identity and sexual orientation. What it means in practice is that every legal protection built on the recognition of gender identity, anti-discrimination protections, health care, legal gender recognition, the right to be addressed by one's name, become challengeable, deniable, withdrawable. States that have begun tentative steps towards gender legal recognition can point to this charter as a continental authority for reversal. The effects cascade in every domain. Healthcare becomes inaccessible. A trans woman seeking HIV treatment who is misgendered is and turned away. An intersex child is subjected to a non-consensual normalizing surgery because the charter invalidates the erasure of intersex identity. A gender diverse person unable to access mental health services because their identity have been pathologized by state-endorsed ideology. Uganda's Anti-Homosexuality Act of 2023 has already driven LGBTI persons away from health services entirely. The draft charter would generalize that effect, not through one extreme law, but through the slow withdrawal of recognition across 20, 30, 40 member states simultaneously. There is also the violence that follows erasure. Reporting on Ghana's Human Sexual Rights and Family Values Bill has documented the murder of intersex infants and widespread violence against intersex children, violence that is enabled when the law endorses the view that such lives are an aberration. When a continental charter calls gender diverse person foreign ideologies, it does not merely affect policy. It tells communities that their neighbors, their employers, their police, their doctors, and their governments may act on the belief that those identities are illegitimate. Hate crimes follow that hate instrument. We are not without instruments, so what do we do to fight back? The African Commission on Human and People's Rights adopted Resolution 257 in 2014. The resolution on the protection against violence and other human rights violation against persons on the basis of their real and imported legal orientation or gender identity. This was the first African Union level instrument to expressly name sexual orientation and gender identity as protected grounds. The draft charter would effectively nullify Resolution 257 by directing states to reject precisely the protection it provides. The African Commission must be pressed to reaffirm Resolution 257 loudly and publicly, and to issue a formal opinion on the incompatibility of the Charter with the African Charter on Human and People's Rights. The Banjul Charter itself, the parent instrument, is equally available. Article 2 guarantees enjoyment of rights without distinction of any kind. Article 3 guarantees equality before the law. Article 4 protects the right to life. These provisions are broad enough to encompass protection for gender diverse persons and strategic litigation before the African Commission and the African Court, anchored in Banjul, is a viable path, particularly where domestic constitutional remedies are blocked. Internationally, the Yukata Principles, first articulated in 2006 and then supplemented in 2007, provide the most comprehensive framework for the application of international human rights law to gender identity and sexual orientation. They are not any binding treaty law, but the authoritative interpretive guidance cited in domestic courts across the world, including in South Africa. Lawyers using the African Commission process or litigating as a sympathetic domestic jurisdiction should anchor arguments in the Yukata Principles alongside treaty provisions. The movement to defend gender diverse lives on this continent is not asking for special treatment. It is asking for the same thing the Soweto uprising asked for 50 years ago: the right to exist, to be recognized, and to be protected. The Charter's answer is no. Our answer must be louder. Why the Maputo Protocol must be defended? The protocol to the African Charter on Human and People's Rights on the Rights of Women and Africa was adopted in Maputo, Mozambique on the 11th of July 2003. It entered into force on the 25th of November 2005. As I have said, 46 of 55 AU member states have ratified it. Only Egypt and Morocco have not even signed. It is by any measure one of the most widely accepted and most progressive human rights instruments on the African continent. Across 16 substantive articles, and most crucially in Article 14, it guarantees rights that represent minimum standards for human decency. Article 2 prohibits discrimination against women. Article 3 guarantees the right to dignity, including protection from all forms of violence. Article 4 guarantees the right to life, dignity, and security. Article 5 calls for elimination and harmful practices, including female genital mutilation and forced marriages. Article 6 sets the minimum standard at the age of 18. Article 14, this article, which has attracted the most reservation, is the article that conservative forces are most determined to destroy, that guarantees women's rights to health, including sexual and reproductive health. It obliges state parties to authorize medical abortion in cases of sexual assault, rape, incest, and where continued pregnancy endangers the mental and physical well-being of the life of the mother or the fetus. These are not radical provisions. They are minimum standards of human decency, and yet they are under attack. The International Commission on Jurists noted in January 2026 that Algeria, Cameroon, Kenya, and Uganda have all placed reservation on Article 14, restricting women's access to sexual and reproductive health care. The African Human and People's Rights launched a formal advocacy framework in May of 2026, developed by Equality Now and a number of other coalition members, specifically to push the withdrawal of these reservations. At the 87th Ordinary Session of the African Commission in Banjul in May 2026, feminist advocates advocated to reaffirm the Maputo Protocol as what it is, a weapon of resistance, solidarity, and accountability. This is the context. On one side, we have decades-long struggle to build and strengthen continental protection for women and girls. On the other side, a well-funded global coordinated movement to dismantle these provisions. The draft charter is the last and the most dangerous escalation. Only South Africa and Mozambique declined. 2 of 22 present nations. Their reasons differed, but that difference matters. South Africa said, while we respect the objects of the Charter, we cannot support provisions that conflict with our constitutional framework and legal obligations. Mozambique's objection was procedural. Its delegation stated that the significance and the sensitivity of the issue required prior consultation, public sensitization, and a joint review of Parliament, government, and other relevant national authorities before any endorsement could be given. One country said this is unconstitutional. The other said we are not ready. Both are defensible, but neither is enough. South Africa and Mozambique were right to abstain, but let me say this clearly. Abstinence is not resistance. We need South Africa to move from a constitutional objection to an active continental objection, to lead a coalition of states that reject this draft charter outright and campaigns against its adoption at the African Union. I want to name what is happening with precision, because naming is the first act of resistance. The anti-rights movement operating through a specific architect. It has been documented by scholars, by ISLA, by the South African Poverty Law Center, by Health Policy Watch, by the United Nations Special Rapporteur. First, funding. Family Watch International is the most viable actor. It is not alone. The movement draws on a network of US-based conservative Christian organizations which have shifted their strategy overseas as they face increasing resistance domestically. They channel millions of dollars through African intermediaries, faith-based organizations, and parliamentarians. They provide training, model legislation, and media strategies. Uganda's Anti-Homosexuality Act of 2023, which prescribes the death penalty for aggravated homosexuality, was shaped by this infrastructure. Ghana's anti-homosexuality bill was shaped by the same playbook. Second, conferences. The Inter-Parliamentary Conferences on Family and Sovereignties are not organic gatherings of African legislators. They are curated events designed to build consensus around a pre-drafted document. This is legislative capture dressed as deliberation. Third, the language game. The Charter speaks of sovereignty, but its authors include foreign organizations. It speaks of African values, but its ideologies, content originates in an American evangelistical movement. It speaks of protecting children while rejecting comprehensive sexual education that evidence shows protects children. The language is the weapon. Our task is to expose the gaps between the language and the reality. 4, treaty withdrawal as a strategy. This is perhaps the most dangerous element. If states withdraw from the Maputo Protocol, there will be no legal basis for upholding them accountable at the African Commission. There will be no basis for individual complaints. There will be no basis for strategic litigation. The entire enforcement architecture collapses. We must treat this as an existential threat to the continental human rights framework. But I do not want to remain in the abstract. Let me bring us to the ground. In South Africa, despite our progressive constitution, despite the choice of termination of Pregnancy Act of 1996, a woman in a rural clinic in Limpopo or in the Eastern Cape cannot access a safe abortion to terminate her pregnancy because facilities refuse to provide her with service, because healthcare workers exercise conscientious objection en masse, and because the political will to enforce the law has eroded. In Kenya, despite ratification of the Maputo Protocol, the reservation on Article 14 means that access to safe abortion remains restricted. Girls are married off at 14 under customary law because the protocol's minimum age of marriage provisions are not enforced. In Uganda, the Anti-Homosexuality Act has driven LGBTI people underground. In Ghana, the new anti-legislation, coming just days before the country hosted this conference to endorse the draft charter, signals a direction of travel, criminalization as policy, exclusion as ideology. These are not abstractions. These are people. These are our siblings, our colleagues, our clients. And the draft charter tells them you do not exist. Your family is not your family. Your body is not your own. Your health is not your own. What must we do? First, legal literacy must become resistant. Second, we must begin to build coalitions. Third, we must follow the money. It's important that we follow the money. We must name the actors, trace the funding, and tell the stories of how African sovereignty is being evoked as a foreign, advanced as a foreign agenda. Fourth, strategic litigation in every jurisdiction where we can. And fifth, we must center the most marginalized. In every debate about values, the people who suffer most are those who are already at the margins: poor women, rural women, sex workers, queer people, trans people, intersex people, people living with HIV, young people denied information about their bodies. A rights framework that does not protect the most vulnerable is not a rights framework at all. I want to close with a reminder of something that need not be said, but apparently it does. The Maputo Protocol was not imposed on Africa. It was deliberated in African capitals by African governments over many years. It was adopted in Maputo by the African Union Assembly of Heads of State and Government. It was ratified freely by 46 African nations. It is the product of African women's movement, of African feminist scholarship, of African legal expertise. It is ours. The draft charter, by contrast, was incubated in conferences funded by US-based organizations whose presence has no mandate from any African people. It deployed the language of African authenticity while importing an agenda that serves American conservative Christianity. It claims to protect the African family while excluding African families. It claims to assert sovereignty while capitulating to African ideological influences. We see through it, and we will fight it. Let us protect the Maputo Protocol. Let us defeat the draft charter. Let us hold our states to account. Let us insist with every tool available to us, legal, political, moral, that gender equality and the right of health are not negotiable, not reversible, and not foreign. They are African, they are constitutional, they are human, and they are ours. Thank you very much.
Thank you very much for such an insightful sharing. And let us hope that the same sanity prevails now in the African nations as had prevailed during the signing of the Maputo Protocol. Thank you very much. Now let me invite Famia Nkansa, Communications Lead at Purposeful, a feminist hub rooted in Sierra Leone. Famia is also co-author of Force Feministas 2025 Until Every Book is Free report on the anti-rights movement threatening the hard-won gains of feminists and queer activists across Africa. Over to you, Famia.
Thanks, Shova. Thank you for having me. Can everybody hear me?
Yes, very clearly.
Hope everybody's having a good morning. It's great to be here and be part of this discussion. So Sibongile put it very eloquently, which is that rights language is maintained in form in this draft charter, but it's weakened in substance, right? And I think that that's something that we cannot ignore. And it's important to examine why. The proposed African Charter on Family Values and Sovereignty is the way it is. And I think it's important to examine it through a comms lens, because this debate is framed as a legal issue, a policy issue, but it's a little bit deeper than that. It's actually a battle of a narrative, and it's a battle of a power. So this proposed charter, it's not simply introducing a new policy framework. It's attempting to redefine the terms of public debate, right? About rights, about gender equality, about sexuality, about health, about governance across the African continent. And that's an issue, because understanding how it works is essential for any of us in this conversation, for anybody trying to defend human rights, to defend gender equality, to defend the right to health. So what's happening from a comms perspective, right? I would like us to go through that. At its core, this charter wants to reframe human rights protections as foreign impositions rather than African aspirations. And everybody who's spoken before me has delved really deeply into that, and so I'm not going to belabor it. But what I think is important to note is that this strategy is not unique to Africa. It's appeared in anti-rights movements across multiple regions. Instead of openly arguing against women's rights, reproductive rights, protections against discrimination, which they know are indefensible, they move the debate towards emotionally resonant concepts, right? Family, culture, sovereignty, tradition, national identity, protection of children. They're really powerful frames because they activate deeply held values. I mean, who doesn't love their children? If you don't love your children, please put your hand up in the Zoom call, because I'm sure you will stand out. The reason why these things work is because they are universal values, but they work particularly well for the African psyche and for the psyche of our lawmakers and the people in public opinion, because they give us the illusion of agency in a continent that feels like it has been subjected to so much and has lost so much agency over the years, right? And I think that this draft charter is really dangerous because of how it frames things, because of how it frames sovereignty as something that the state is entitled to versus the individual. So when they come and they portray gender equality as a threat to social stability, when they portray, sexual and reproductive rights as foreign agendas, when they mobilize fears about social change, and then they present themselves as defenders of ordinary people against the elites, It's not accidental. Anti-rights actors are great at comms. They are great at co-opting narratives. They are great at co-opting emotional language. And the danger, and I think the deficit to us, is that it allows them to frame what we talk about as like legal mumbo jumbo, right? It allows them to say this is development lingo. And the stuff that they're talking about is real. The stuff that they're talking about is based on identity. It affects the day-to-day. It affects the lives of Africans. It affects people's, lived experience. And that resonates really deeply. And I think that this shift from the language of rights to the language of values, again, is super, super important and worth noting. Why the Maputo Protocol is significant is important and worth noting, but it's already been covered by my colleague, so I'm not going to belabor it. What I think we should be looking at is whether this draft African Charter is an extension of the African Union Convention on Ending Violence on Women and Girls, which came out a few years ago. Because I think that this stuff is a journey, and it's worth tracking the journey and then interrupting every sort of stress point or access point or point of shift, right? So when the AUCE-VAWG came out a few years ago, it seemed really progressive. It talked about preventing violence against women and girls. But once we went deeper, we saw that it lacked gender protections. It didn't protect against harmful traditional practices like FGM. It didn't have any cover for sexuality, for intersex people, for gender nonconforming people. So the Pause for Purpose campaign, which Purposeful was part of this push to not allow states to replace the Maputo Protocol with the AUCE-VAWG. Now, there's a clear drift from the AUCE-VAW drift to the draft charter, to this African Values Charter. And this through line is notable because Maputo is significant, like everybody said, not only because of its legal protections, but because of what it symbolizes, right? It demonstrates that gender equality and women's rights aren't these external concepts that were imposed on Africa. They are principles that African states themselves negotiated, adopted, committing to advancing. Crucial narrative point, because one of the strongest responses to claims that these rights are foreign imports is that African women, activists, policymakers, legal experts, governments played a central role in shaping the protocol. The AUCE-VAWG happened quickly, was very small, was not done in consultation, didn't have that evidence that gender justice has, these African roots, African leadership, African legitimacy. And there was rightfully a call to hit pause on it, examine it, and strengthen the protocol versus replacing it with that. So in a way, the protocol is the benchmark, right? It's the most progressive human rights treaty that we've seen at a regional level. And it didn't just protect women from violence, it established women as rights holders with autonomous legal claims against the state. I mean, it has articles that deal with women's rights to control fertility, women's right to decide whether they want to have children, access to contraception, family planning, abortion. So communications-wise, Maputo is built around a rights frame. It says women have rights, states have obligations, governments can be held accountable for failing to uphold those obligations. Now that architecture is important because the center of gravity is the individual. The center of gravity is the woman. It's not family, it's not culture, it's not natural identity, it's not sovereignty, it's a person. Then AUCE-VAWG comes in, looks progressive on paper, but it doesn't build on the Maputo framework as strongly because it puts the woman as a subject, the subject of women, violence. This is to prevent violence against women and girls. So a woman becomes the subject of violence that needs to be protected. So to say that it's anti-rights, it might be a bit of a stretch, so it's not a claim I'm going to make, but I think we can all agree that the AUCE-VAWG was less rights-based than Maputo. It contained weaker treatment of, structural gender discrimination. It omitted key reproductive rights language. It lacked some of the concrete legal entitlements found in Maputo. It didn't foreground reproductive autonomy, and it relied sort of more heavily on implementation and coordination frameworks than enforceable rights standards, right? So Maputo asks, what rights does a woman have? AUCEVAWG says, how should institutions respond to violence against women? And then we go to this family values charter, which goes way beyond that and is now framing existing international norms on sexuality, on gender identity, on comprehensive sexual education as threats to family integrity, as threats to parental authority, and as threats to African sovereignty. So think of it almost like those Russian nesting dolls, the matryoshka dolls where one doll is inside another doll is inside another doll. They've put family integrity inside parental authority and put parental authority inside African sovereignty. And in there, the rights of the individual are totally lost, right? Because now the African continent is the thing that has rights, not people. So Maputo says women's rights. AUC-VAWG says protection from violence. Now Family Values Charter says family values, sovereignty. The subject of the sentence changes, and now the woman is not even the primary political actor. She's not even the survivor. She's not even she's not even in the game. The family and the state runs everything, and particularly in this continent where the family is very rarely a site of safety or a site of protection or a site of nurturing and growth, but oftentimes for women specifically, a site of violence, a site of erasure, and a site of shame. That is a really, 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 really meaningful semantic shift, because it's not just semantic, it's ideological. And we should pay attention because anti-rights actors don't start by attacking rights directly. They start by changing frameworks, right? And they love to change a moral frame, because political education, political communications research, it consistently shows that who defines the frame wins the debate. And the Family Values Charter is attempting to substitute a frame, go from autonomy, equality, dignity, bodily integrity to sovereignty, parental authority, tradition, cultural preservation. And they managed to do this without explicitly arguing against women. They do it by co-opting feminist language, because feminist language has proven to be so useful in getting us the rights that we've gotten over the last 4 decades. And by relocating women into this hierarchy where the other interests become more important, all of a sudden, women's rights become negotiable. And I think that one of the things that is happening in this conversation and happens in conversations across the continent, sometimes to our detriment, is that we're thinking of anti-rights actors as policy actors. We're thinking of them as people who are coming to change laws, to influence policy. And that is their end game, but it's not really what they do best. At their core, they are narrative actors. Their objective is not to pass a law tomorrow. It's not to change everything in a week or two. They want to make the unimaginable imaginable. It's to make a law imaginable in 5 years. In Ghana, the World Congress for Families Conference, which kicked off all of our anti-LGBT legislation, happened in 2019, which was 7 years ago. And this year, they are seeing enormous fruits of their labor, right? So before rights are rolled back institutionally, they're rolled back culturally. Before the protections, disappear from the legal text, first they disappear from the conversation. They disappear from the stories that we're telling ourselves, from the identity that we're looking for, from how we are thinking of ourselves as people, as nations, as communities, of the things that we hold dear. And the Family Values Charter is a narrative intervention before it is a legal intervention. It's not only what it is proposing that is frightening, it is what it is attempting to make seem reasonable. And I think one of the things that the anti-rights movement has done really effectively has been to understand that people don't mobilize around policy. they mobilize around identity. None of us, even those of us who work in the legal field, wake up excited about, treaty obligations. We wake up excited about our lived realities, our children, our culture, our future, our community, and what those treaty obligations or what those laws might mean in real time for the people and the things that we care about. And so when we make these discussions and we don't connect to those emotional anchors, when we have these policy discussions where anti-rights actors outperform us, it's not because their policy positions are more defensible. It's because they are telling an identity story very effectively, and particularly on a traumatized continent like the African continent, where a history of colonialism has made us so desperate for any kind of autonomy and self-actualization that will buy any lie that is sold to us if it is framed as coming from a position of strength. And so I think that what should frighten us deeply about this draft charter is that it comes out of these interparliamentary conferences. And the interparliamentary conferences are significant because these family values conferences started as a way for anti-rights actors to descend on the continent and try and mobilize people to come and listen to what they had to say. So they invite lawmakers, they invite traditional rulers, they invite interreligious bodies, and they basically almost like have a talent show where they have these Africans sitting down, captive audience, and they try to sell us on their policies. The interparliamentary conferences are different because now we have African lawmakers gathering, bringing other African lawmakers together and saying, let's come up with our own instruments that borrow from these people's playbook, and let's frame it as grounded in continental autonomy and sovereignty. And that's petrifying. It petrifies me all the time. I think the conference that just happened in Ghana is a great example because in anticipation of this conference, they were able to pass this bill that had, basically run out the clock. And there's a video going around that I think people find heartening where the delegate from South Africa refused to sign on to the charter. But I think that one of the things that we don't necessarily realize about this draft African Family Values Charter is that they are not necessarily trying to get everybody just to adopt it wholesale. They are also selling it as something that lawmakers can take apart piecemeal and then implement in their own countries as and when they choose, right? So the fact that African lawmakers are having these conferences themselves, they are getting other parliamentarians from other African countries to attend. They are drawing up instruments that they can then influence other countries to adopt. Even if they don't adopt this African charter wholesale, should still worry us because they can take elements of it and pass them as local law. And the way I think for me it has really sort of set in is that we're thinking about this almost like people being offered a meal. It's like a plate of jollof rice or, a plate of pilaf or something that someone is offering African lawmakers, and they have the option to say yes or no, and then it moves on. But it is much less like a meal and more like a plate of hors d'oeuvres, or what we think of as, we call them small chops in Ghana, where somebody brings a platter and it has several little goodies on it, and you can pick what you like. And it's so much smarter because it's presenting lawmakers with an array of options that they can implement as they see fit. And this has real repercussions on people's lives. The Maputo Protocol isn't perfect, but it's the best instrument we currently have. And what we're seeing is a narrative shift that is eventually going to land us in a place where rights are rolled back on an unprecedented scale. Because what we're seeing right now is an unholy alliance between global actors who feel like they've lost control of their own countries and see our continent as this final frontier for their fascism and authoritarianism and religiosity. And they have managed to come here and find local enemies of progress to befriend and fund, and together they push these conservative agendas forward. And these agendas are seductive to our communities because they are written in the language of autonomy, of sovereignty, of African self-actualization, and because they come from these deeply emotionally resonant narratives. What we know on this call and what we who do this work know is that these things aren't innocent. This draft charter is not innocent. What they're trying to do to Maputo Protocol is not innocent. It's not about a law. And we need to fight them with everything we have because they are coming for everything we have. Thank you.
Thank you very much, Famia. And thank you for raising your concerns. And the only thing we hope, or I sincerely hope, that common sense and goodwill prevails. Now let us listen to anti-rights and anti-gender pushbacks outside of Africa and the negative impact such a draft charter in Africa can have on gender equality and human right to health globally. I invite my friend, mentor and guide, Dr. Pam Rajput, Professor Emeritus, Punjab University, and former chairperson of Government of India's High-Level Committee on the Status of Women. Welcome, Pam, and can you please share your insights on what threat such a draft charter poses to countries and communities outside of Africa? And what can we do? Over to you.
Thank you. Greetings to the moderator, Shobhaji, all the co-panelists. Can you hear me?
Yes, very clearly.
All the co-panelists and participants attending the discussion today on a very, very pertinent and critical theme. I take the opportunity first to congratulate the organizers and in particular She and Rights for organizing this very timely discussion on the protection of Maputo Protocol, the most progressive women's rights treaty, and of course, you know, the anti-rights and pushback that we are witnessing in the form of proposed charter. But let me also say that I am so privileged today, privileged to hear such excellent presentations from my African sisters. And if such strong people are there, I wonder the unholy alliance will succeed in denying and negating the rights they already have. I think I was wondering why Shobha is inviting. Shobha, thank you indeed. I have really learned a lot today from the presentations that have been made. No, I will not speak on the protocol or the proposed charter. But as Shobha says, you would like to hear the viewpoints from a person outside the African continent. And let me at the outset say to our sisters who are here, who are not here, that we are with you. And we stand together in the backdrop of the global backlash that we are witnessing with regard to women's rights. Anti-right actors are operating globally. And I therefore feel that feminist solidarity must be global. Indeed, I would like to focus on the global South solidarity. So it is not an issue that we are watching from a distance or we have just an academic interest. In fact, as a student of the system, I feel that the world is shifting. In fact, I can say it is drifting from the era of 90s. And as a person having been involved in the global, regional, national movement for women's rights, I'd like to share and draw the attention that before we talk about this, that the African Charter that, I would like, Shobha, permit me to digress, and it is very important that I mention that African Union has been admitted to G20. I'm sure most of you know about it. And it was in the year 2023, the same year. And why I'm mentioning African Union joining G20? G20 in 2023 was hosted by India. And the declaration of G20 is very, very significant. And that it included in the declaration the concept of women-led development. Now, can there be women-led development if women do not have rights? If women do not have freedom? If women do not have the choices they want to make? If we don't confine them only to a particular section of women and not the diverse women, not the marginalized women, not the women of all ages for that matter? So it is women-led development. And I'm saying this, African Union is a signatory to that political declaration. And also, we have engagement groups, and W20 is an engagement group of G20. And this W20, of course, after India, we had the meeting in Brazil and thereafter South Africa. Again, the declaration that came out, there is a book that has come out on W20, and if you happen to go through it, you will find that this issue of sexual health, sexual and reproductive rights, and the diverse woman finds very significant space in those documents. Not only G7 or G20, it is true of G7 as well. G7 only a day before concluded in France, and W7, Women's Engagement Group of G7 has as much come out and included in the, official statement, the women's right to health and in particular SRHR. So it is not only Africa's issue, it is a global issue. And also I want to share something that, we are losing the gains of Beijing. We are losing the gains of ICPD in this whole backlash. And even I am not sure about the SDGs, as one of the speakers mentioned. We are not likely to get them fulfilled by 2030. Now the year given is 2064. And the gender equality that we talked in the Universal Declaration of Universal Declaration, and also CEDA for that matter. And according to Secretary General, it will take 300 years to have gender equality. Now, in that background, this SDGs particularly, where the key is no one shall be left behind. Now, all this, you see, we are really, if you look carefully, we are having the reverse picture for that matter. And when I say reverse, I'm reminiscent of the gains of 90s. And I would like to quickly mention that one, of course, was the Vienna conference, where clearly it was declared women's rights are human rights. All that we are talking today, we got it in 90s. That was in Vienna, women's rights are human rights. And then came ICPD, where, the SRHR was recognized. I'll come to this again. And then, of course, the Beijing Declaration and Platform for Action, which recognized economic, social, and political rights. There was a chapter on health, where the sexual and reproductive rights were recognized. And this was reinforced, everything was reinforced in the. And also I want to make a mention that in the 21st century, in 2015, as we call it, transformative agenda, these sustainable development goals were adopted. And in I happen to be in the corridors of the UN. As I said, I have been participating in all the CSW and all these UN meetings. I happen to be in the corridors of the UN when the the post-2015 development, the development agenda was adopted. And at that time, the UN Women, in partnership with the People's Republic of China, organized a meeting of the heads of the states and government. There were heads of the states and government from Africa as well. And what was the theme of that? The UN women wanted, to move from promises to commitments. But I want to draw the attention to a poster that was there outside the UN. What did it say? 50-50 by 2030. And the other was patriarchy will come to an end by 2030. Are we anywhere nearby that? You see, this whole African charter is going in the reverse direction. So we are losing. And I remember very distinctly, the huge crowd of African women who came to Beijing, not only Beijing, at every CSW. Our sisters from Africa come in large number, not only to contribute, but also to see to it that the rights of women, But what I said I will share it with you later also, and that is in June 2000, there was a special session of the UN General Assembly. It was called Beijing +5. It was in June, and if I remember the date correctly, it was 9th of June 2000. That time I was invited to address the UN General Assembly as a representative of the civil society representing Asia Pacific region. And as I was waiting on the sidelines, this you will not know anywhere. This is personal, but I'm sharing. As I was sitting and waiting on the sidelines, there was a woman sitting next to me. Now, who was this woman sitting next to me? It was none other than Dr. Nafis Sadek, who was the Secretary General of ICPD. The Secretary General of Beijing was from Africa, but of ICPD was Nafis Sadek. She was from Pakistan. And what I noticed was she was also to speak, so we were in queue over there. What I noticed was that she had tears in her eyes. So I, took I just went to her and asked her, what is wrong? Why are you having tears in your eyes? And you know what she said? She said, I'm afraid in times to come, the rights regarding SRHR will be wiped out. This is what she said on June 9, 2000. This will be wiped out. It will be all undone. And I assured her, no way, ma'am. It will not be possible at all. But lo and behold, today, right, we are witnessing those attempts. And in fact, you see, last 2 years, I would like to particularly make a mention, as we have been engaged with Beijing +30, I wouldn't call celebration, but certainly assessments for that matter, from local to regional to global level. It was in Asia Pacific region, it was in Africa region, and every region had, done the assessment. And I wish to draw your attention to two meetings of the Commission on the Status of Women, 69 and CSW 70. 69, what happened in 69, which was the Beijing +30th year, that was 2025. As I mentioned, I have been attending the UN Commission on the Status of Women since 1994 without break. And this time in CSW 69, which was the 30th anniversary of the Beijing, the political declaration was to be adopted. And lo and behold, political declaration was presented to us on the very first day of the Commission on the Status of Women. But inside story I want to share is that for the first time, there was so much of debate and dissent within the commission itself, right? That there seemed to be no possibility of unanimity having been reached. But the commission was very concerned, which was headed at, the chair was from Saudi Arabia. They were concerned that the political declaration is unanimously adopted. So how did the unanimity was reached? Unanimous because there were objections to the word gender equality in the text. Now, gender equality, there is a problem with the word gender itself with certain countries, and I'm sure you understand which country, particular country is. So there was no unanimity, and they said, no, this word gender equality has to go away from the document. So finally, a consensus was reached. How was the consensus reached? Gender equality was retained at the cost of deletion of SRHR, right? So SRHR for the first time, to reach the consensus, it was deleted. But interestingly, the next year, that is Commission on the Status of Women this year, 70th Commission on the Status of Women, when the document political, that was political declaration, but here we were going in for agreed conclusions, which Commission mostly does it. 5 years declaration, but every year, agreed conclusions. Again, there was difference of opinion. Again, the countries were. And in the history of the Commission on the Status of Women, first time there was a dissent recorded to the agreed conclusion. So one country dissented and 6 countries abstained from the document. So this is what we are noticing, that there is a pushback for that matter. And more than that, it is not an issue of, what I want to stress is that it is not an issue only of Africa. The backlash is global now, and that is why we need to unite together for this. And also I must mention, and that is UN80. There is an attempt now to have UN80. There is an attempt to reform the United Nations. And of course, the ground given is that there is financial crisis. So which are the countries who are not paying the finances to the UN, and the financial crisis is there? Everybody knows about it because they don't want gender at all, the word gender at all. And so there is a proposal, and this is a serious proposal, as serious as the African Charter is, and that is that UNFPA and UN Women, they should be merged, right? So the reason on this is given again is financial, but to me, the reason is deeper, because once that is done, the impact will be on women's rights and also the whole agenda on gender equality. I feel very concerned about this proposal of merger of UN Women and UNFPA. Of course, as a part of the women's major group, we have signed, and that signature campaign has been going on against this. But I want to share with you that earlier there was UNIFEM, right? So UNIFEM neither had adequate funds, nor it had, the head of the UNIFEM, a position that the person could participate in the UN decision-making processes. So there was a campaign, we called it a gender architecture campaign, when there was a move to have, one UN. And I still remember very distinctly that in the South Asian region, we collected millions of signatures for this new gender architecture, which should have adequate finances, as well as, its agenda should be on gender equality, and also the position of the head of the UNIFEM, so that she could participate in the decision-making processes. So one feels very, very sad. That's why I said we are drifting. We are going backwards from the gains that we made in the 90s of the last century and the first decade of this thing. So this is going on, and my fear is once UNFPA is merged into UN, right, the whole issue of the right to health, particularly in terms of sexual and reproductive health, is going to suffer for sure. So friends, it is not an Africa issue. It appears that, you have the African Charter, yes, It is immediate for you, and it has to be addressed. And that is the reason we are here. And this is all the more important because this issue is not only regressive, it is contagious, right? If it happens in South Africa, it is the other countries are going to, follow it. And I am sure when Poland restricted abortion in 2020, immediately the right-wing groups in the US started, in favor of women, and the situation of right to abortion in the US. And again, when Uganda passed Anti-Homosexuality Act in 2023, the lawmakers in Hungary to Texas started citing it as a model. So it is not question of only being regressive. It is a question that it is contagious and many other countries will follow. So Maputo belongs to Africa, but fate, I will say, belongs to all of us. And human dignity, nay, human rights are not divisible by geography. So when you say Africa, it is going to affect us, it is not divisible by geography. It will certainly have impact on development justice. I feel very strongly about it. And that means weakening of all sectors, education, health, and economies, and threaten even the progress of SDGs, particularly SDG 3, SDG 5, SDG 10, and SDG 16. Having said all that, I think I have taken more time than I should have. And let me conclude by saying that the anti-rights narrative, I felt so happy listening to all the speakers from Africa. I bow my head to your intelligence, to your arguments, and to your commitments. And having said that, I would say the anti-rights narrative travels quickly through transnational conservative networks. This is what we need to guard. Of course, there was a very good suggestion that you should take up this issue in the Interparliamentary Union meeting. But as I said, these transnational conservative networks are also very, very strong. We have to be watchful. We have to be, time wouldn't permit. We have faced these conservative forces within the building of the UN itself. Some other time I'll share with you. So patriarchy is transnational, and so are anti-rights movement. So it is not Africa alone. All these anti-rights movements are transnational, and resistance, therefore, also must be transnational. We should stand by you. We should be there with you at every platform for that matter. And so for that matter, I repeat my sentence, resistance, therefore, must be transnational. So the question is not what does Africa debate mean to Africans? Question is, what does it mean for the future of women's rights everywhere? We need to challenge anti-rights narrative. We need to build cross-regional alliances, reaffirm universality of rights. Human rights cannot be selectively applied or culturally withdrawn at the will of some people. Rollback in one region can become a precedent elsewhere. So must we, resist collectively, and the feminist solidarity must be global. And we are adding our voices in favor of the Maputo Protocol and against the proposed African Charter. Let us push the pushback for gender equality. With these words, I do hope that our collective will, our collective struggle, our collective voices, more so of the grassroots women with us, wherever we are, we shall, continue to strike and face the forces against gender. And we wish that we continue to move for gender equal and gender just world. With these words, I thank you once again for listening to me patiently. And I do hope that as and when you raise the hand, we also raise the hand with you. Together we shall move, and together we shall continue with our struggle. Thank you very much.
Thank you so much, Pam, and thank you for so well articulating all our fears and concerns. And yes, together we can. Let us hope for that. We are already short on time. We have crossed the time, but we will take up a few questions which we already had earlier from our registrants and participants. Also, there is a question from Kerry Kulinen from Health Policy Watch, not the Family Watch. Given that the groups pushing the charter assert that the family is male-headed, does not this undermine the equality of women and children under law, insulating husbands and fathers against being prosecuted for gender-based violence and rape within families? Sibongile, would you like to respond to that, or any speaker?
Hi.
Yes.
Good. May you please repeat the question?
It says that given the groups that are pushing the charter, they assert that the family is male-headed, then doesn't this undermine the equality of women and children under law, insulating husbands and fathers against being prosecuted for gender-based violence and rape within families?
So one of the things that I did put on the chat is the link between the Convention on Ending Violence Against Women and Girls and this charter. Rights. And I think we should call the convention anti-rights because it is a gateway to the convention. It starts this normative regression by defining family as provided for or defined, by member states. And this is the first kind of articulation in a regional kind of treaty, international treaty, of what this draft charter is asking for. This is a version of sovereignty that says member states must be responsible for how they define or provide for the family. So this insulation that Kerry is referring to is not only coming through the draft charter, it is already part of the legal instruments that were recently developed by the African Union. And so we should see this convention as part of the attack of Maputo. It's not just that it is substantively weak, was procedurally flawed, or structurally incoherent, is that it actually takes, rights that already exist. And in Africa, this is very important because when most countries gained their independence from the British, they had this Lancaster model constitution, which had what African feminists fought against called the clawback clause. What the clawback clause did was to remove family, personal law, and customary law in some constitutions from being subjected to the equality provision. So in one level, it was saying everyone is equal, and then in another level, it was saying, but not in personal law matters, not in family law. So what we are seeing with this convention is basically bringing back what many people fought for after Beijing, fought against the removal of this provision. So the second wave of constitutions and the third waves of constitution removed these kind of clawback clauses. So when we engage with the AUCVOC, we have to see it, in this way, that the insulation of the family is basically what they want to see, because whilst one cannot actually say that it was drafted, by the anti-rights actors, but when people fail to pay attention to what we are losing, even if they are well-intentioned, they end up harming us by opening a gate. Because when you read the convention and what the charter is asking for in terms of family values and all of that, the provision in the AUCVOC that talks about prevention of violence introduces this idea of African values as part of prevention, of violence. There may well be kind of positive African values, but what are they? Because we have seen how they are being divined or kind of co-opted to take away from gender equality. So it is important that we don't have the reading that is kind of hopeful of these instruments, but see how they actually come together to reinforce each other and then provide this kind of normative framework of all the things that we have.
We can't hear you, Sivangali. Okay, you're muted now. Okay. We have a question for Famia, that it is very alarming to see anti-rights wingers are using gender rights language, and in this garb, they are advancing anti-rights, anti-gender, and confusing the weakening definitions and languages too. How do you see one can counter this? Yes,
Hello?
Famia. Yes, hello. Yes, Famia.
Yes.
Yes.
How we counter it is tough. I think naming it and recognizing it is the important thing. Last year, there was a Strengthening Families Conference that's organized by the Church of Jesus Christ of Latter-day Saints, and it was organized in Sierra Leone. It started in Ghana in 2019, went to Nigeria, went to Cote d'Ivoire, then went to Sierra Leone, and then tomorrow it is in Monrovia. And one of the things that was so stunning about that conference was when you read the transcripts and you see the language from the First Lady of Sierra Leone, from the MCs, on its face, it looks like it could come from any feminist conference. They have gotten very, very good at co-opting feminist language, the language of women and girls, the language of protection, the language of rights, of advancement, and using it to erode rights. And I think that what we are able to do is not necessarily take back the language, but to identify it when it is happening and then to expose the burden that it actually imposes on women versus the autonomy that it gives to women, right? Because one of the things that family values language does when it co-opts feminist language is that it doesn't challenge patriarchy. It embeds feminist language within the language of subservience. So it says women can be judges, women can be bosses, women can run homes, women are the backbone of society, women need to have their own money, women need to be economically empowered. But in the same breath, it says women need to pray for their families, women need to make sure their children are taken care of, women need to make sure their children are not on social media. You are the spiritual leader. And so all it does is that it literally doubles the labor. And I think when we are able to identify that, that is probably the only way that we can expose it for the hypocrisy that it is, because it situates all the power in the hands of men and the state, and then it just makes women actors in a mechanism that doesn't serve us. And I think it is also important to call out the people who are being attached to this feminist language. So when anti-rights actors go after the Minister of Gender, the Minister of Children Welfare, get first ladies to speak at their conferences as a way of using their soft power, we need to name that in the public sphere and say, this goes against a women and girls agenda. How are you in bed with these people if you claim to be for women and girls?
Very right. Very well said, Mama. So true. Pam, there is a question for you. Is it possible to mobilize governments outside of Africa for them to uphold commitment to legally binding CEDAW and other promises and give it primacy and raise this issue of the African Charter on global platforms like UNGA to urge African governments to in September 2026 UNGA?
I think it's a very good question, and this is one platform. So there are organizations working on CEDAW, right? I think that should be one way, because SIDA is one platform which should be used. And I assure you that in our advocacy group, I am going to raise it, this whole issue of that at how on different platforms, right? When when we meet, this issue can be taken up. Of course, SIDA has the optional protocol also, right? Where you can, raise it is not necessary. The individuals and the groups can raise the issue. See that this is happening. It can be done. It can be done.
Okay. Thank you. I think we have already exceeded the time by more than 17 minutes. So with this, we come to the close of today's session. And my sincere thanks to all our speakers and participants for joining us so vibrantly in this important discussion, which is critical for upholding our rights. It is undermining all efforts to uphold individuals and women's rights and aims to end women's and child's rights and all individual rights and autonomy in the garb of promoting what they call cultural sovereignty and family values. We have to counter it. And before we end, I just remind our media personnel not to forget to apply for the fourth edition of the She and Rights Media Awards, the link of which is given in the chat box, and where you will get all the other information also. And namaste till we meet again, and let us hope for, again, as I say, a feminist fossil fuel